Starting a new business with a partner can feel like one of life's most exciting adventures. It's a journey filled with shared dreams, big ideas, and the powerful energy that comes from two people joining forces. You see a future, and you see it together. But as with any great journey, the path can have unexpected turns. One wrong legal step, one misunderstanding, can end up costing you so much more than money. It can cost you your dream, your time, and even a cherished friendship. Before you shake hands and dive in, let's talk. I want to walk you through some simple but crucial legal truths that every aspiring partner needs to understand. We're going to make this clear and simple so you can build your business on a foundation of trust and clarity. This conversation isn't about scaring you or filling your head with complicated legal jargon. It's about empowering you. It's about giving you the tools to protect the very thing you are working so hard to create. Think of it as building the strong, steady foundation for the beautiful house you plan to build. You wouldn't start construction without a blueprint, would you? The same is true for your business. We will explore 7 key areas that you and your partner must discuss before you officially join forces. Each one is a pillar that will support your partnership, helping it stand strong through challenges and successes alike. This is your aha moment for business. The point where you realize that a little planning now saves a world of heartache later. My promise to you is that we will break this down in a way that makes sense. The very first decision you and your partner will make is one of the most important: choosing the right legal form for your business. Now, you might think a partnership is just a partnership, but it's not that simple. It's like picking a type of vehicle for your journey. Are you building a small cart for 2 or a bus that can carry more people and protect you from the elements? You have choices. The most common is a general partnership, where 2 or more people agree to run a business together. But there are also limited partnerships and limited liability partnerships. Each one comes with its own set of rules, its own map for how things operate. Why does this matter so much? Because the business structure you choose has a direct impact on 3 huge parts of your life: taxes, your level of control, and, most importantly, your personal financial risk. In a general partnership, for example, the law often doesn't see a difference between you and the business. This means if the business owes a debt or gets sued, your personal assets, your home, your car, your savings, could be on the line to pay for it. An LLP, or a limited liability company, on the other hand, can create a protective wall between your business and your personal life, giving you precious peace of mind. So, what is the simple, powerful step you can take right now? It's to have an open conversation about your comfort level with risk. Talk to your partner about what you each have to lose and what you want to protect. Once you've chosen your business structure, the next essential step is to create a partnership agreement. What is that exactly? Think of it as the constitution for your business. It is a written contract created and signed by all partners that lays out all the rules of the road. This document is your shared understanding of how the business will run, who is responsible for what tasks, how you will make important decisions, how you will share the money you make, what will happen if you decide to part ways. It is your single source of truth, a guidebook you can turn to whenever a question or a disagreement arises. Because if you don't write down your own rules, your state's laws will make them for you. Every state has default partnership laws that kick in when there's no written agreement. A verbal agreement or a handshake might feel good in the moment, but memories fade and interpretations differ. A written agreement prevents misunderstandings that can grow into painful, expensive conflicts. It's not about mistrust. It's about clarity. Commit to putting everything in writing before you officially launch your business or deposit your first check. Now let's talk about money. This can be a sensitive topic, but avoiding it is one of the biggest mistakes new partners make. Before you go any further, you must have a crystal clear conversation about ownership and profit sharing. Who owns what percentage of the business, and how will you split the profits that come in? It's not always a straightforward 50-50 split. Document specific numbers and examples. Define what fairly means. Every business, no matter how small, requires countless decisions every day. From choosing a new coffee supplier to signing a major client contract, someone has to be in charge. In a partnership, it's crucial to decide ahead of time who makes which decisions and how those choices are made. Without a clear system, you risk paralysis or stepping on each other's toes. Business momentum is everything. If your agreement doesn't allow action on time-sensitive deals, you could miss opportunities. Clear governance lets you be nimble while preserving both partners' voices. List major decisions requiring unanimous consent, taking on a large loan, signing a long-term lease, changing core services, bringing on a new partner. Day-to-day operational choices can be delegated to one partner or decided by majority if you have more than two. Assign authority by strengths. Finance signs off on budgets up to a limit. Marketing manages ad spend. Define roles and limits clearly in writing. This empowers each of you to act confidently within your roles. This structure doesn't limit your freedom. It creates it. Work in harmony, like a well-rehearsed orchestra. Let's talk about something that can keep a new business owner up at night. Personal liability. It means your personal belongings could be at risk to pay for business debts or legal troubles. The money in your savings account, your family home, your car. In many partnerships, especially general partnerships, the law views you and the business as one and the same. If a client sues and the business can't pay, creditors may reach personal assets. Your dream should never become a personal nightmare. Form an LLP or an LLC. Follow formalities and get proper insurance. Keep business and personal finances completely separate. When you're starting a partnership, everything feels full of promise and excitement. The last thing you want to think about is it ending or having a major disagreement. But life happens. Goals change, people retire, move, or pursue different dreams. Sometimes partners die or become too ill to continue. Not having a plan is like sailing without lifeboats. If a partner leaves with no process, chaos follows. How do you buy them out? How much is their share worth? Can they start a competing business across the street? Include a buy-sell agreement. Triggers like death, disability, retirement, and voluntary departure. Define valuation by formula or an independent appraiser. Specify funding, lump sum or installments. Many use life insurance to fund buyouts. Add a dispute resolution ladder. Mandatory mediation first, then binding arbitration. Faster, cheaper, and more private than court. Plan worst-case scenarios during good times to protect everyone and the business. In today's economy, the most valuable things aren't desks or computers, they're ideas. Your business name and logo, a secret recipe, your customer list, unique software. Alongside IP, there's confidential information, financials, marketing strategies, and business plans. The make or break question: who owns them? The creator or the business? If you don't define ownership, a departing partner could take core assets and compete. Include a clause. All IP created for the business by any partner during the partnership belongs to the business entity, not the individual. That ensures the business retains logos, client lists, inventions, and creative work if someone leaves. Use NDAs in early discussions and add confidentiality provisions to your agreement, covering both during and after the partnership. Protecting your ideas is like locking your most valuable treasure chest. Take these topics, sit down with your potential partner, and have the real, honest conversations. Money, control, risk, and the what-ifs. We've talked about so much today, and I hope you're feeling clearer and more empowered. It all starts with choosing the right business structure to protect your personal assets. Then create a written partnership agreement, your business's constitution, that outlines everything: how you'll share profits, who makes the final call on big decisions, and, critically, how you'll handle disagreements or a partner's departure. Put in writing who owns the brilliant ideas and the confidential information that make your business unique. These aren't just legal to-dos, they're the 7 pillars of a strong, respectful, resilient partnership. Addressing them up front removes hidden obstacles and unspoken assumptions. You're building a foundation so solid it can withstand pressure and time. Honor the trust between you by making expectations real and tangible. This is the work that turns a fragile dream into a lasting enterprise. Use these topics as your agenda. Don't fear disagreement. it leads to alignment. Once you outline your terms, get a brief consultation with a business lawyer and a tax advisor. It's an investment that pays for itself many times over. A great partnership can achieve more than one person alone. By making smart legal choices early, you protect that power. Set yourselves up for a journey that's profitable and grounded in mutual respect and confidence. You have the vision. You have the drive. Now you have the knowledge to build it right. Go forward with confidence and build the future you both deserve.